Good evening, sir. Good evening, classmates. I'm Reinalyn Santiago, and I'm going to report Article 1339 to 1346. So let's start.
First, let's start with Article 1339. It states that failure to disclose facts when there is a duty to reveal them, as when the parties are bound by confidential relations, constitutes fraud. Article 1339 is about fraud, or simply in Filipino, panloloko. Let us define first what is fraud. It is a crime of using dishonest methods to take something valuable from another person. So when there's a duty to reveal facts at hindi mo sinabi, bagkus inilihim mo pa, then that constitutes fraud. A neglect or failure to communicate that which a party to a contract knows and ought to communicate constitutes concealment. Yung concealment naman ay hiding something or keeping something secret. The concealment contemplated in Article 1339 presupposes a purpose or design to hide facts which the other party ought to know. In this case, concealment is equivalent to misrepresentation. Sinasabi naman sa second paragraph na ang concealment ay kaparehas ng pagsisinungaling. Kapag nagsinungaling ka to the other party at siya'y may karapatan na malaman yon, then that constitutes concealment. Article 1339 provides for an example kung kailan mo masasabi na there is a duty to reveal facts. Sabi daw, when the parties are bound by confidential relations, so the best example for that is partnership. For instance, Sian and Yani are partners engaged in the real estate business. Here, the parties are partners, so they are bound by confidential relations. Nalaman ni Sian na si Carlo ay interested na bumili ng parcel of land na pagmamayari ng partnership even for a high price. Kaya ang ginawa ni Sian, kinonvince si Yani na ibenta sa kanya ang share nito and then ibinenta naman ni Sian kay Carlo sa mas malaking halaga. In this case, Sian is guilty of fraudulent concealment because as a partner to Yani, he has the duty to make disclosure of facts pero hindi niya sinabi. And if merong fraud by concealment, meaning that contract is voidable. But if the case was unintentional, the basis of the action for annulment is hindi maituturing na fraud, kundi mistake or error lang. So for example, if the sale was at the initiative of Yani, and Sian unintentionally failed to inform Yani sa ino-offer ni Carlo, in that case, the cause for annulment is mistake or error. To summarize Article 1339, if you are bound by confidential relations or partnership at naglihim ka, nagsinungaling, o hindi ka nagsabi sa partner mo, then that constitutes fraud or panloloko. Next, according to Article 1340, the usual exaggerations in trade when the other party had an opportunity to know the facts are not in themselves fraudulent. This article is about usual exaggerations in trade. It is the natural tendency for merchants and traders to resort to exaggerations in their attempt to make a sale at the highest price possible. When the person dealing with them had an opportunity to know the facts, the usual exaggerations in trade are not in themselves fraudulent. The first paragraph stresses the rule of caveat emptor, meaning let the buyer beware. A buyer must be always on his guard, dahil nga mako-consider na natural lang sa mga merchants and traders na maging exaggerated para kumita. In effect, the law does not consider such exaggerations, even if known as false by the party making them, as amounting to fraud that will affect the validity of a contract. In second paragraph, ang batas daw ay hindi kino-consider yung mga exaggerations bilang fraudulent. Kaya dapat, as customer, they are expected to know how to take care of their concerns and to rely on their own independent judgment. For example, mga pampapayat at mga pampaputi na products. Imbis na sabihin nilang magandang product nila, pero mas maganda yung sa iba, kadalasang sinasabi ay, our product is the best and first in quality. Ang ekspresyong nabanggit ay hindi na bago sa atin as customer. So any person who relies on said exaggerations does so at his own peril. Article 1341 states that a mere expression of an opinion does not signify fraud, unless made by an expert and the other party has relied on the former's special knowledge. Article 1341 is about expression of opinion. To constitute fraud, the misrepresentation must refer to facts, not opinions. Ordinarily, a mere expression of an opinion does not signify fraud. As a general rule, kapag human expression or just an opinion, it is not considered as fraudulent. Pero kung galing sa isang expert, ito ay matuturing na fraud. Under this provision, malalaman natin kung ang opinion ay fraud if it is must be made by an expert. Galing mismo sa isang eksperto yung opinion. Second, the other contracting party has relied on the expert's opinion. Kung ang isang party ay naniwala dahil nga mismong eksperto ang nagsabi. And lastly, the opinion turned out to be false or erroneous. Para mas madali nating maintindihan, here's an example. Si Felix na isang farmer ay nakakita ng singsing. Si Felix ay walang alam tungkol sa mga precious stones. Pero para sa kanya at sa tingin niya, ang singsing na napulot ay isang diamond ring. Kaya ibinenta niya ang singsing kay Ben. In this case, there is no fraud even if it turned out that ring is not a diamond dahil ang statement ni Felix ay merely an expression of an opinion. However, kung si Felix ay isang expert sa mga precious stones at ibinenta ang singsing kay Ben, sabay sabing diamond ring iyon, dahil sa naniniwala si Ben na si Felix ay isang expert at nag-rely siya sa special knowledge ni Felix, the contract is voidable on the ground of fraud because Felix, being an expert, is making a misrepresentation of fact and he cannot escape liability by expressing it in the form of an opinion. According to Article 1342, misrepresentation by a third person does not vitiate consent, unless such misrepresentation has created substantial mistake and the same is mutual. Article 1342 is about fraud by a third person. A third person has no connection with the contract. Consequently, a misrepresentation by him does not vitiate consent. A party should not be made to suffer for the imprudence of another in believing the fraud of a third person. The presumption is that both contracting parties are acting in good faith. Si third person ay yung taong hindi kasama or kabilang sa contract. Kinoconsider sila as strangers sa isang kontrata. Sa Article 1342, kapag ang third person daw ay nag-commit ng fraud, ay makakakuha lang ng damages and does not vitiate consent. For example, si Johnny ay bumili ng lupa kay Mark for 2,000 pesos per square meter. The reasonable price of lands in the same vicinity is 3,000 pesos per square meter. Pero ibinenta lang ni Mark kay Johnny ng 2,000 pesos per square meter kasi naniwala siya sa sinabi ni Lucas na 2,000 pesos per square meter lang daw ang market value ng lupa. In this case, the contract cannot be annulled unless na mapatunayan na nagkaroon ng sabwatan or fraud between Johnny and Lucas para bumaba ang price ng lupa na ibinebenta ni Mark. However, if the misrepresentation by the third person has created substantial mistake and the same is mutual, that is, it affects both parties, the contract may be annulled but principally on the ground of mistake, even if the deceit was without a complicity with one of the parties. So, si Article 1342 ay nag-provide rin ng situation kung saan ang fraud that is committed by a third person has created substantial and mutual mistake ay pwedeng ma-annulled ang isang kontrata. For example, Sandra is an owner of parcel of land at si Bianca ay naghahanap ng lupa on which to build a factory. Then si Celine, a third person, ay sinabi kay Bianca at Sandra that the place where the land is located is actually an industrial zone. The strength of that misrepresentation made by Celine, Sandra and Bianca then entered into a contract of sale of the land. But it turns out na yung area ay residential zone na kung saan hindi pwede mag-construct ng factory. Under the facts, the sale may be annulled because of substantial mistake which is mutual. Article 1343 states that misrepresentation made in good faith is not fraudulent but may constitute error. Article 1343 is about the effect of misrepresentation made in good faith. If the misrepresentation is not intentional but made in good faith, it is considered a mere mistake or error. Fraud is definitely more serious than mistake. Hence, the party guilty of fraud is subject to greater liability. Nabanggit sa Article 1343 ang salitang good faith. So ano nga ba yon? It means that the person making the false statement believe it to be true. Sinabi lang sa Article 1343 na ang misrepresentation na galing sa good faith ay isa lang error or mistake. In short, magkaiba ang fraud sa mistake. Yung example ay katulad at makikita rin sa Article 1341 wherein si Felix na isang farmer ay nakakita ng singsing. Si Felix ay walang alam tungkol sa mga precious stones, pero para sa kanya at sa tingin niya, ang singsing na napulot ay isang diamond ring, kaya ibinenta niya ang singsing kay Ben. But it turns out na the ring is made out of glass. In this case, there is no fraud dahil hindi rin alam ni Felix na ang singsing na binibenta niya ay gawa lamang pala sa glass. Kumbaga, in good faith, akala niya diamond ring yon. Then, the misrepresentation is not fraudulent but an error. Article 1344 states that in order that fraud may make contract voidable, it should be serious and should not have been employed by both contracting parties. Incidental fraud only obliges the person employing it to pay damages. There are two kinds of fraud: the causal fraud, or also known as dolo causante, and incidental fraud, or dolo incidente. Causal fraud, or fraud employed to secure the consent of the other party, which is a ground for the annulment of a contract, although it may also give rise to an action for damages. Causal fraud ay fraud na siyang dahilan kung bakit pumayag ang isang party na pumasok sa isang contract, and it may vitiate consent. Paano nga ba masasabi na ang fraud ay isang causal fraud? First, kung ito ay seryoso. Second, it should not have been employed by both contracting parties or they should not be in pari delicto. In pari delicto is a Latin word for unequal fault, meaning ang dalawa or higit pang tao ay guilty of a crime. Third, it should not have been known by the other contracting party. Bali ang isa sa party lamang ang nakakaalam at gumawa ng causal fraud. And lastly, it should be invoked by the proper party. Example, si Arthur ay nagbenta ng lupa kay Jaden at sinabing ang lupa ay absolutely free from liens and encumbrances. At dahil doon, binigay ni Jaden ang kanyang consent. Then when the sale was registered, it was found that a lease pendants notice was annotated. Lease pendants is a Latin word for suit pending. In this case, merong concealment or causal fraud, and it is made in bad faith na kung saan ito ang dahilan kung bakit si Jaden ay nag-enter sa kontrata. So he can ask for the annulment of contract. Incidental fraud, or fraud likewise employed to secure the consent of the other party, but which only renders the party who employs it liable for damages. Incidental fraud ay hindi ground for annulment of contract, hindi katulad sa causal fraud, pero magiging liable ang guilty party to pay damages. For example, si Sam ay may kontrata with David na mag-deliver ng 500 kabans of rice with the price per kaban of 1,300 pesos. Noong una, si Sam ay nag-deliver ng 300 kabans of rice at hindi muna dineliver yung remaining 200 kabans dahil sinabi niya na tumaas ang presyo ng bigas. From 1,300 pesos, naging 1,600 pesos per kaban na, kahit hindi naman talaga totoo. In this case, the fraud is dolo incidental because it is committed to the existing contract. According to Article 1345, simulation of a contract may be absolute or relative. The former takes place when the parties do not intend to be bound at all. The latter, when the parties conceal their true agreement. Article 1345 is about simulation of a contract. Simulation of a contract is the act of deliberately deceiving others by feigning or pretending by agreement the appearance of a contract which is either non-existent or concealed or is different from that which was really executed. So, simulation of a contract ay mutual agreement by parties para manloko or linlangin ang ibang tao sa pamamagitan ng hindi totoong kontrata or sa pamamagitan ng pagpapanggap or pagtatago ng true intentions. basic characteristic, purpose, and requisites of simulation. The basic characteristic of simulation is the fact that the apparent contract is not really desired or intended to produce legal effects or in a way alter the juridical situation of the parties. Ang basic characteristic ng simulation ay hindi talaga kagustuhan ng parties na umentor sa isang contract. The nullity of simulated contract is based on the absence of true consent of the parties, which is essential to a valid and enforceable contract. The purpose of simulation is to hide the party's true intent or to deceive or defraud third persons. Sinabi ko nga kanina sa meaning ng simulation of contract na tinatago ng parties ang true intentions nila kung bakit sila umentor sa isang contract. The requisites for simulation are an outward declaration of will different from the will of the parties. The false appearance must have been intended by mutual agreement, and the purpose is to deceive third persons. So para mas maintindihan pa natin lalo kung ano ang simulation of contract, here's Article 1346. An absolutely simulated or fictitious contract is void. A relative simulation, when it is not prejudice a third person and is not intended for any purpose contrary to law, morals, good customs, public order, or public policy, binds the parties to the real agreement. There are two kinds of simulation. The first one is absolute simulation, or when the contract does not really exist and the parties do not intend to be bound at all. Absolutely simulated or fictitious contracts are inexistent and void and are not susceptible of ratification. The parties may recover from each other what they have been given under the contract. Absolute simulation ay void kasi both parties do not intend to enter into contract. Nagpapanggap lang ang parties na may contract sila para ma-deceive yung ibang tao. For example, Lisa is indebted to Jenny. Nung nalaman ni Lisa na sisingilin na siya ni Jenny, siya ay nagpanggap na ibebenta niya ang kanyang lupa kay Fred, her father-in-law. Si Lisa ay hindi naka-receive kahit single centavo for the deed of sale she executed, and siya pa rin ang may-ari ng lupa as the contract was merely simulated or fictitious. Bali wala talagang contract of sale sa pagitan ni Lisa and Fred because the parties do not intend to be bound at all. The second kind of simulation is called relative simulation, or when the contract entered into by the parties is different from their true agreement or the parties state a false cause in the contract to conceal their real agreement. The parties are bound by the real agreement, provided it does not prejudice a third person and is not intended for a purpose contrary to morals, good customs, public order, or public policy. Kung sa absolute simulation ay hindi talaga nag-i-exist ang contract, sa relative simulation naman ay may nag-i-exist na contract pero hindi pinapakita ng both parties ang true intentions kung bakit sila pumasok sa isang kontrata. For example, Justin and Kyle entered into a contract of mortgage or sangla. Pero gusto ng dalawa na itago yung mortgage kaya umagri sila na in the form of a deed sale na lang. In this case, there's a relative simulation dahil nakatago ang true intention nila which is mortgage na naging deed of sale. Sa example na nabanggit, pumapasok din dito yung tinatawag na two juridical acts, the ostensible act and the hidden act. Ostensible act is the apparent but fictitious document or conduct executed by the parties. It is always void. Sa example, ito yung contract of sale. And hidden act is the true or real agreement contemplated by the parties. It is valid if it is not contrary to law, morals, good custom, public order, public policy. Sa example, ito yung contract of mortgage, which is yung true agreement ni Justin and Kyle. And that's all for Article 1339 to 1346. I hope you learn and understand my topic. Thank you!